Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. As part of our ongoing series covering the November 4th elections, we're going to visit Judge Chris Bruno of Orleans Civil District Court. Judge Bruno is running for re-election to the bench of Division F at District Court, or CDC, a position he has held since 2009. Judge Bruno's opponent in the race is attorney Ruth Ramsey, who unfortunately did not respond to our request to join us today. We'll be speaking with Judge Bruno about the election and the various issues and challenges that CDC faces. CDC handles civil lawsuits in which large amounts of money may be at stake. Among its many other cases, the judges who are elected to the bench of CDC are responsible for adjudicating many important cases that affect all of us in one way or another. So stay tuned, and we'll speak with Judge Chris Bruno of Civil District Court after this quick break. Welcome back to the show. On Tuesday, November 4th, today's guest faces re-election to the bench of Division F at Civil District Court in New Orleans. Judge Chris Bruno is with us on Power of Attorney. Welcome to the show, Chris.
Thanks for having me.
Right to the questions. First question, define the role of a judge, and what is it about you that you believe qualifies you for re-election to this very important post?
Okay. Well, the role of a judge is people like to hear the word referee. Or an umpire calls balls and strikes. So in a judge trial, I'm the trier of fact. In a jury trial, I'm the referee. So if there's an issue, evidentiary issue that has to be decided, because we don't want to poison the jury with bad evidence. So the judge has to be very careful to exclude anything that may prejudice or make the jury consider something that's not relevant, we call it. So that's really what the role of the judge is. And also to resolve matters, if possible, to dismiss matters if they're not worthy, I say the word worthy, of being brought to a jury or a judge trial. And I'll talk about that a little later. My experience is vast. Previous to being elected a judge in 2008, I was a litigation attorney with Bruno & Bruno for 20 years, trying hundreds of cases, jury trials, thousands of motions, depositions, training me and training me to be the best lawyer I could be. And I say that as like the Marine slogan. And what I did was I went as far as to be certified by a National Board of Trial Advocacy, which is a peer-reviewed group that requires you to take a 6-hour exam in Atlanta. Went to Atlanta and took this test because I wanted to just demonstrate to my clients that I was proficient and above average in the practice of law. So that's what I did before I ran for judge.
Okay. And let's change gears a little bit. What technological improvements would you like to see implemented at Civil District Court?
Well, we've already done that, okay? Considering the dilapidated state of our building, which you've been in,
sure, many times.
It's unfortunate that we are probably the only parish in the state that doesn't have either a renovated courthouse or a new courthouse for some reason. I don't know why that is. But we have actually implemented technological changes. We have TVs in all the courtrooms with video ability playback. We have the IT department is fantastic at CDC. We have, if you want to have an Elmo, which shows the documents on the screen for the jury, we can even have a video conferencing deposition from an expert in another state, live in a courtroom now. It's just the shell of the building.
Technology is already there.
Already there. So the judges and my colleagues and I decided, even though we have to live with this dilapidated building, we're going to at least try to make it user-friendly for those individuals who come through the system.
Right. So there are already a lot of technological improvements, even though the building needs some help, or a lot of help. Are there technological improvements you're still working on realizing or making happen?
Well, there are, but remember, we are separate. There's the clerk of court, who is the keeper of our records. Now, she is working right now on digitizing to make the documents and pleadings available online. That is going on right now, so that we're trying to work on a new filing system. I don't think you're going to get the federal court online filing as soon as we'd like it to be, but we are working on access to pleadings online.
Now you mentioned federal online filing.
Yes.
You're saying we're not quite at the point where the state court system, which you're in the state court system. You're running to be reelected to the state court. You're referencing how things are being done in the federal court system, where many documents and much information can be accessed online by lawyers and even some litigants or clients, correct?
Correct. So in federal court, you have e-filing. Now, individually, my court, I actually allow lawyers to scan and send their memos to me by email. I allow, in fact, my pretrial order is when I meet with the lawyers in pretrial conferences, they sign it and give me their email address, and I email the pretrial order to them. So I'm already online in my division, and I allow pleadings to be filed. Remember, they amended the Code of Civil Procedure to actually allow service by email. So we are getting close to a paperless system. We're not there yet, but in my court, I do a lot of things paperless.
Okay, and for those people who don't have a lot of savvy or knowledge in the law system, service by email, explain what that means.
So a lawyer has to sign, when a lawyer signs a pleading, the lawyer is stating to the other side that what is in this pleading is an accurate statement. And there's an article called 863 that if you sign a pleading that has scandalous matter in it and something that's untrue, you can be sanctioned. So there's a method by which the certificate of service used to be by mail. Well, now, since we had fax first, you could fax it. Then they amended it to allow email, so you can fax, email, and regular mail. That document you file in court has to be served on the other side, or you could be sanctioned.
Served, and it could be by
email, fax, or regular mail.
Okay. All right. Well, let's move on. What is the most pressing issue that you see facing Civil District Court, CDC?
Well, it's not really dealing with in my court. There's no issue that's pressing regarding how I handle my docket, because my docket is completely up to date. Trial dates are given in 6 months. I work the lawyers very hard.
And 6 months is very good for those people out there who don't know that in other courts the wait for a trial can be a lot longer than that.
It can be years, even in federal court. And so the biggest problem, and go back to my early answer, is the building. It's just not, it's almost an access to justice issue. We have no rooms for juries to deliberate. A jury has to go into another courtroom to deliberate. There are no conference rooms for attorneys to talk to their clients. So you have your attorneys and clients sitting in the hallway where potential attorney-client privilege issues can arise, violation of those privileges.
Because someone might overhear the important conversations you're trying to have in privacy.
And so we have no conference rooms, we have nowhere for the jury to deliberate. The elevators fail. We've had a leaking courtroom. On 2 occasions, water has come into a courtroom from above on the maintenance area of the top floor of the building. So it's an embarrassment to the state, and people wonder why we're always judged and lowest on places to try cases. Well, that's why.
How do you deal with that financially? How do you deal with that?
Well, it's very difficult because, as you know, we're a self-funded court. Our filing fees pays all the filing fees pay for everything in our court, except obviously our salaries. We're state employees, so the judges are paid by the state of Louisiana, but everyone else is paid through filing fees. So you have to have a mechanism by which you can service debt. So if you're going to borrow money to build or renovate, you have to have a mechanism to service debt. But which means, how do you do that? You have to raise fees. So you got to be very careful of how you determine what you're going to use to service debt. So you could have an access to justice issue on raising fees. So it's trouble. It's a problem.
Okay. Well, let's change the gears a little bit. Give us an example of and maybe without having to name names, of a very interesting or memorable case that you have had to deal with or struggle with in the past. Let's not talk about an ongoing case, obviously.
Well, no, they're not ongoing, but let me tell you the most difficult cases I have to deal with are the asbestos cases, because the documents are voluminous. For example, I have, my pretrials. We were talking about that earlier. So I'll meet with the lawyers.
And just for people's edification, describe what pretrial is.
So when the lawyers are ready to get their case set for trial, they set what's called a pretrial. It's a meeting with the court. Now, I do the meeting myself.
The lawyers and the judge meet face to face.
Typically, the lawyers meet with the minute clerks. Mm-hmm. When I got elected, I said, you know what, that doesn't make sense to me. I'm the lawyer first, I'm the judge. I want to know what this case is about, because I want to set it so that those people who come to court, the jurors, witnesses, will know that they're going to be here at trial on that date and will be back to work on a set time. So when I have the meetings with the lawyers, we go over, I understand the case, obviously, because I've read the record. I sit and I talk about the experts they're going to use, the document production. So the most difficult type cases are the asbestos cases, because we had a case And so my pretrial order requires all the objections to be resolved. Remember we talked about ensuring that nothing bad goes before the jury,
right,
and that the jury's time is quality time in our system. I rule on all those objections the week before trial. And I've had asbestos cases where we had 30,000 documents to go over, 10,000 documents in other cases. And I reviewed all those documents to rule on the admissibility. So it's a lot of work, but you know what? It's what you sign up for. And because, again, we don't want the jurors to be burdened of sitting there for 2 weeks waiting for the objections to take place and leaving the courtroom every 10 minutes or so. So that's what.
And just, again, so people understand, because you know, I'm a trial lawyer too,
right,
and I've tried a lot of cases, and in fact, I've been in your courtroom. When the judge and the lawyers are arguing over objections, the jury has to kind of cool their heels. They have to just wait while these things are being resolved. So if the judge, for the first time, is looking at a stack of documents that's 100 or 1,000 pages, they might be waiting a long time while their kids aren't being attended to, their work, their employers are waiting for them to get back to work. So you've already previewed and had the lawyers argue these objections with you beforehand?
Right, it's common sense. So you see, you're thinking about, wait, am I going to start my trial? Oh, objection to the document. Oh, ladies and gentlemen, would you please step out for 20, 30 minutes? What sense does that make? So everything is done. So when you come to my court as a juror, 9 o'clock, we call it voir dire, starts to question the jurors on their qualifications. Evidence is introduced and the case begins.
Okay.
No stoppage for any document objections.
We're going to need to take a break here. So after the break, we will continue our judicial forum with Judge Chris Bruno. Welcome back to the show. We're continuing our conversation with Judge Chris Bruno, who is running for Civil District Court in New Orleans for re-election on November 4th. Let's get back to our questions. So you've just gave us a detailed picture of what it's like when you try or prepare to try cases. Brings me to my next question. Tell us about your experience and why you believe your experience matters in your bid for re-election to judge in Civil District Court.
Well, you know, judicial elections are all about experience and qualifications, because people expect the judge will know the law, that the judge has actually practiced law, tried cases, argued motions, appeared at a pretrial conference to meet a judge. And what I found very interesting is that my opponent stated at the Alliance for Good Government, I've never signed a pleading in Civil District Court, never tried a case, never argued a motion, never appeared at a pretrial conference. And I thought that, you know, comparatively, I said, that's interesting, because as a judge for 6 years, I handled 13,000 rules and motions in domestic court, an additional 2,000 rules and motions in the last 3 years on the regular docket, jury trials, judge trials. In my practice, it's this, the experience of taking depositions and arguing motions and trying jury trials. It's just invaluable that a lawyer walking in the court has the smallest expectation that the judge will at least have appeared in a courtroom in the court where that lawyer or that judge is presiding. And so I have demonstrated through my streamlining methods that the system can work for everyone. And the goal is to get people in and out of the system without disrupting their lives, getting them back to work and back to family. And guess what? It's worked. And I want to continue that, what I've done in the past 6 years.
How hard is that to get people, not only the lawyers, but their clients, the jurors, the witnesses, the experts, people who know they get that jury summons, or they know they have to show up because they're being sued or they're suing, to get them in and out of there efficiently?
Well, it begins again at the pretrial, and why I know exactly how long the cases are going to take. So I get a record, lawyers are coming in, say at 9 o'clock. I'm looking at the record. This is an auto accident. Or let me give you a better example. This is a medical malpractice case, is what I did the latter years of my practice. Okay, I see the allegations. Okay, I know there's going to be an expert witness, so I'm going to need expert reports. There's going to be a need to take discovery. We're going to set deadlines for discovery. I have a feeling
deadlines for discovery,
right,
for people who don't know law lingo. What is that?
A discovery is a method by which you can go on, we call it almost like a fishing.
When you're the lawyer, not the judge.
Lawyer. When the lawyer goes out and he wants to know what evidence are you going to present at trial, so I can be ready to defend the evidence. So if you're going to introduce the medical record, of my client, then I want to know what you've gotten in your request for those records. Or if you want to know what medical records that or doctors your client treated with or hospitals, you better get those records. Or you want to know who the witnesses that you're going to call, you send out what's called a written questions to the other side.
So you find out what the other side
Yes.
knows, the other side finds out what you know,
right.
and nobody is ambushed at trial.
Right. A good lawyer will do that. Not all lawyers are doing that, though. So a good lawyer wants to get all that information ahead of time. And I'll tell the lawyers in my pre-trials, I say, look, be aggressive on your discovery, because the word advocate is not a bad word. You're fighting for your client. Because my deadlines for disclosure of witnesses, once it passes, it's over. If you have not done your due diligence.
You have to tell the other side who your witnesses are.
Right. And so that's a good lawyer. And so I make these lawyers work hard. And it's because I want everyone to get in and out, jurors and witnesses again. So when I know the number of witnesses, I say this is a 4-day trial. And guess what? When the jurors come in, it's a 4-day trial. And we don't work late, John.
And you can guess, you can estimate the time it takes, because you know certain witnesses are going to take 2-3 hours on a stand to give their testimony. Experts might take less time or more time depending on how complicated the case is. And then when they're done presenting the evidence, then you give instructions to the jury. Then the jury goes into the deliberating room, if you have one, or in another courtroom, so they can decide who wins or loses, and then if they win, how much to compensate the
right,
the
exactly.
winner.
But think about this. So when you have everything done ahead of time, when the jurors come in, they say, well, how long are we going to be here? Because they're all upset to begin with. I said, you're going to leave at 4:30 every day. And why is that? Because everything has been done ahead of time. So all the jury's doing is listening to the evidence and trying the case. It's simple. It's a simple process.
Okay. Well, let me change gears. Ever since Katrina, most New Orleanians, people from the greater New Orleans area, they saw that Hispanics are very much a part of the gumbo of New Orleans. The census figures from 2000 and then 2010 and a lot of other statistical variables show that Hispanics are very much a bigger and rising part of our life as claimants, as people being sued. What are you doing in your court, and what do you pledge to do in your court to address that?
That's a great question, because now I have to say that does extend the trial somewhat, and that's why pre-trying the case is so important with the judge. Because if you go to the minute clerk and you don't mention that you need an interpreter, because a lot of times some of the people, not just Spanish, we've had from nationalities from all over the world. And so you have to have an interpreter. So if you're not looking at this case and understanding, and I've had a case like that in the past, I said, so we're going to need an interpreter, right? That's going to add 30 minutes to 45 minutes. So we always consider, that's why I know the case ahead of time. Now, the other issue is whether the system's open to all. Of course it is. I mean, everybody is treated the same way in the court, but you have to be mindful of that some people have not learned the English language, so we have to consider, and we have we have access to great interpreters. And you have to make sure that a lot of times lawyers are, I don't know this interpreter. So we make sure we have a qualified interpreter, because sometimes the lawyers are Spanish speaking and they know what the interpreter is saying. So you got to be very careful when you get your interpreter that they're interpreting verbatim. A lot of people don't understand that. You have to interpret verbatim. I say, is that verbatim? Yes, it is. So that's one of the things you got to make sure it happens.
Well, I happen to be half Hispanic. I represent a lot of Spanish speakers, and sometimes I have to, I don't want to say challenge, but ask the interpreter to double check that translation.
Right.
All right. Well, now I want to change gears to yet another question, a different question. There's been a lot of reporting in the paper recently. We've seen it in years past where judges get some of their educational training on out-of-town trips. Some proponents defend that, and they say, you know what, you want to get the best and the brightest judges. They should be able to get the same perks that excellent lawyers get in other law firms, to attract the best and brightest to take these jobs that don't even pay as much as good jobs in the private sector. Let them get good education wherever it's taught. Some people say, wait a minute, this is taxpayer money that pays through the state, and if they can get the same or similar education locally, make them get it locally. Do you have an opinion on that?
All I can speak of is from my own personal experience. I have never taken a single dollar from the Judicial Expense Fund for traveling. The only two CLEs, continuing legal education programs, I had the court pay for were for my mandatory 6 hours. Now the Supreme Court mandates that judges have to take 6 hours or 5 hours through the judiciary, through the Judicial College, which is the arm of the Supreme Court, and that was in New Orleans. Both of those seminars I went to were in New Orleans. They were $350 a piece. So okay. I said, I'm mandated to go to these, and so I requested that the court pay those two seminars, but they were in New Orleans. Okay. I've never taken a penny to travel on anyone's dime but my own.
Okay. Another question, and we've asked this of the different judicial candidates in the other forums we've done on this show. Can you think of a decision or an action you took as a judge or as a lawyer that was controversial, but you took you made the decision knowing that there was going to be controversy, and how did you handle the heat or the controversy that arose afterwards?
Well, in 2004, I had the privilege of being appointed by the Louisiana Supreme Court as a judge pro tempore. Means that I'm the temporary judge over a docket where the judge had gotten elected to the Fourth Circuit. And the case where the challenge to the Marriage Act, the Defense of Marriage Act in Louisiana, was filed in my court. And after looking at that very hard, hearing arguments, I declared that act unconstitutional. That was a very difficult decision for me. It was the right decision in my mind, and actually, I thought I'd get backlash from some of the Christian groups, but some of the friends of mine who are Christians, and they said, you know what, you took a stand. And I ruled based upon what I thought my interpretation of that statute was. And that was probably my proudest moment when I was a pro tem judge. And it was probably the most controversial thing I've ever done.
Well, thank you for that answer. Now, one of the big problems facing judges, and I think you've touched on this, is having a crowded docket and moving the docket. How have you been able to get your docket in shape? You mentioned that you can usually set cases for trial within 6 months. What have you done in order to get your docket moving smoothly, and what plans do you have for handling your docket if reelected?
Okay, so what I do is, we talked about the trials, and we mentioned briefly motions. All right, motions, we call substantive motions, are the motions that a lawyer would file. If, say, you're sued, and you're saying that you have no claim against me because there is no law, there's no law that allows this claim, what's called a no cause of action. You haven't pled a viable claim. Or you're arguing that there's no facts in dispute, your claim is meritless. So those are substantive motions. So somebody's trying to stop the case before it gets to the judge at jury trial. I set those hearings 3 Fridays out of the month, every month of the year. Most judges do it two Fridays out of the month. We also talked about discovery. I set discovery motions every Thursday of every month, 12 months out of the year, because discovery is so vital, because if you don't get the documents ahead of time or get the case, the information.
When you're trying to get information from the other side, so learn what the other side knows.
So I do that. Now, what I did recently in the last 2 months, I've implemented a quick discovery setting. So, because I understand how important document production is and evidence production is, and that's what delays cases. If you file a motion to compel the document or evidence production, it gets set that Thursday in 4 days. And I issue an order telling the other side that the hearing's taking place Thursday. And again, that's done. I have had lawyers with their just like a V8 moment hitting the head. Thank you, Judge. Yeah. Thank you for doing that. I go meet with lawyers. I've met with lawyers the last 2 weeks, and they are like, that this helps us so much, because it takes months and months and months to get the documents. So again, streamlining, getting the matter in, people in and out of the system has been my philosophy, and it works.
Okay, Judge, this is going to be our last question, because we're just running out of time here. I'd like your thoughts on any last word, comments you'd like to share with our viewers beyond what you've already shared, something you'd like them to consider in addition to what you've already said as to why you believe you deserve to be reelected to this important post. Anything additional that you'd like to share?
All I can say to people is that I am your servant. I'm a public servant. I don't do this job for any other reason than to give back. You know, I was very blessed and I have to say lucky in my practice for 20 years. And I had the opportunity to do something. And so when I ran for judge, because I wanted to get cases moving. When I was a judge, you've experienced it. Well, sometimes judges just don't let you get your case tried. And so I said, I'm going to stop this when I get elected. And I have. So now I've got a system that works. Lawyers, which is remarkable. The bar poll, New Orleans bar poll, that's all the lawyers in New Orleans who are a member of the Bar Association, of the New Orleans Bar Association, voted 85% in favor of me in my reelection. And you know why that is? Because I've done my job, I moved my docket, I'm responsive to the lawyers, I'm responsive to people, I give them their day in court. All people have their day in court in my court. Everyone is allowed the same justice. And that is why the lawyers are happy with me. And those are the people who practice in the court. Those are the people who need the system. And their clients are happy, they're happy. So they want me to continue what I've done. And so the qualifications are there, the experience and the on-the-job work that I've done indicates that I'm qualified and I'm ready to proceed for another 6 years.
Well, I'm so grateful to you for taking this time, and I'm grateful to you for being here. You can find out more about the candidates in this race, Judge Chris Bruno and Ruth Ramsey, on our show website at johnredmannpoa.com. There you can also learn where you need to go to vote, as well as watch every episode of this show and submit your legal questions that we'll try to answer on the air. A special thanks to Judge Bruno for participating in this Judicial Candidate Special. We'll see you next time on John Redmann, Power of Attorney.